In local government, it is the employees and volunteers who keep things ticking. From police, fire, roads and utilities, to housing, recreation, libraries, and citizen services. Most have dedicated their entire careers to the community they serve, and many of us even live in town. In local government, we have a strong respect for each other. Unfortunately, a few employees and volunteers around the state have made headlines for the wrong reasons. They've become subjects of lawsuits alleging harassment and discrimination. These are violations of basic civil rights. And as the municipal manager, I need to be certain that we have the basic procedures in place to protect our employees, volunteers, and the public. Please join me as I meet with our attorney, police chief, fire chief, and the executive director of the local authority. I want to thank all of you for coming to Town Hall this morning. As you may know, there have been incidents of harassment and discrimination in the workplace around the state. Such incidents are unacceptable. And I thought it would be helpful to have our attorney talk to us about precautions we need to take.
Thank you. To begin understanding this issue, federal and state laws cover such important areas as discrimination, safety, violence, and harassment. Now, because of the efforts to address these issues in recent years, things have improved. However, we still have a way to go.
I really appreciate you coming to this meeting. My officers and I are very concerned about personal legal liability. I mean, we put our lives on the line every time we go to a call, and we thought that as governmental employees, we couldn't be sued.
My volunteer firefighters have the same concern. When you're called out at 3 o'clock in the morning, you don't want to be thinking about legal liability.
I understand. Now, while as a governmental employee or volunteer, you enjoy many legal protections, you can be sued if you violate someone's civil rights. That's a whole different area of the law. There is no absolute defense, such as immunity, against a civil rights claim.
But isn't this covered by the insurance?
As much as possible. Under the law, insurance often cannot cover the punitive damages awarded when someone deliberately and knowingly violates someone else's civil rights. In other words, in some cases, you can be held personally liable. However, there is no reason to be concerned if everyone follows a few basic procedures.
You're right about that. Too often, petty squabbles build to a big feud. And before long, the department is tied up for years in lawsuits. And much of this could be avoided if we just slow things down and let cooler heads prevail.
Didn't these laws originally focus on personnel decisions, such as hiring, promotions, and discipline?
Exactly. You must be careful to make personnel decisions in a non-discriminatory way. However, today these laws are far broader.
For example,
Harassment lawsuits have increased substantially because most people are no longer willing to tolerate workplace intimidation. At one time, someone who was the target just had to take it. No more.
In other words, bullying.
Exactly.
It's important that we communicate this to everyone involved in the town's organization. Under no circumstance make jokes, use nicknames, or pick on someone based on their race, religion, national origin, age, disability, gender, or sexual orientation.
Come on, there's nothing wrong with a little give and take now and then.
It is too easy to dismiss bullying behavior as just give and take. It's far more serious than that. Bullying is an escalating process where the victim is the target of systematic acts meant to intimidate.
Good point. One of our objectives this year is to have every manager and supervisor complete a course on how to spot and deal with workplace harassment and bullying.
Do these laws also extend to volunteers?
Yes, the anti-harassment policy also applies to volunteers connected with the municipality.
I recently heard that firefighters were sued when they harassed a gay couple who lived next to the firehouse.
The behavior of the firefighters you're talking about was unacceptable and reflected poorly on the town. But there is a valuable lesson to learn here. We not only have to be strict about harassment among people within the organization, we also have to be concerned about harassment towards the general public.
I suppose we'll even have to prohibit employees and volunteers from dating each other?
There is a rule of reason here. There's nothing wrong if people want to date. However, you are right that the anti-harassment policy extends to sexual harassment as well.
Specifically, the policy refers to making unwelcome sexual advances, making remarks that are offensive, engaging in physical contact with a fellow employee or volunteer, and creating an intimidating, hostile, or offensive environment by such conduct.
I also noticed that many of these lawsuits in the paper complain that someone was disciplined or harassed because they blew the whistle or reported some alleged wrongdoing.
Probably the most basic protection that any citizen has is the right to bring wrongdoing to the attention of the appropriate officials without fear of retaliation. As we just discussed, this is why our community's complaint procedure covers employees, volunteers, and the public.
Just who's considered to be a whistleblower?
Under the various laws, a whistleblower could be an employee, a volunteer, or a member of the public who complains in good faith of discrimination, safety issues, and harassment, including sexual harassment. Specifically, that would mean disclosing or threatening to disclose anything that the individual reasonably believes is illegal. Or it could deal with providing information to an investigation into any violation of law or regulation. It could also mean objecting to or refusing to participate in any activity that the individual reasonably believes is illegal or is incompatible with a clear public policy mandate concerning the public health, safety, or welfare.
It seems to cover everyone.
Almost. To be considered a whistleblower, the individual must actually bring the alleged wrongdoing to the attention of the proper authorities. This is why we are required to regularly communicate the complaint procedure to everyone concerned.
Can you require all complaints in writing?
No. While we can encourage that complaints be in writing, verbal complaints are sufficient under the law.
What constitutes retaliation?
Well, certainly any official act, such as suspension, termination, or demotion. But it also includes anything that could have the effect of discouraging someone from speaking out.
In one case, an individual was teased by the other members of the department after complaining about something, and the courts ruled that this teasing was considered as retaliation because the department didn't take sufficient steps to stop it.
In other words, this is another type of illegal harassment?
Exactly. Further, if you're aware of retaliation, harassment, or other violations of civil rights, you can't ignore the situation, even if the victim hasn't complained yet.
What do we do if we receive a complaint?
Well, first, don't go running to the person who has been accused of the wrongdoing and ask if the complaint is true. We have an official investigation procedure. Follow the procedure and take the complaint seriously.
That makes sense. You don't want the accused person to confront the accuser. That will only make the situation worse.
Exactly.
What if the complaint is false?
Well, if the person who made the complaint knew the complaint was false, then that person is subject to the appropriate penalties for knowingly filing a false complaint. The whistleblower law only protects people for making complaints in good faith. You can't use the whistleblower law to harass someone. That violates the other person's civil rights.
We also have to make clear that if you feel that you've been the victim of harassment, you can talk to anyone in management, not just your superior. In the police department, we have a very strong chain of command. But the chain of command doesn't apply when there's alleged harassment.
You should be aware that the governing body has adopted the 5-part program required by law to protect employees, volunteers, and members of the public.
The courts are very specific on this. We are required to adopt a clear policy prohibiting discrimination, harassment, and other violations of civil rights, establish a complaint procedure, provide training to both supervisory and non-supervisory personnel, monitor the program for effectiveness, and communicate management's unequivocal commitment to enforce this policy.
Do all volunteers have to take this training?
It's a good question. The term volunteer is very broad. The municipality assigns appropriate training to volunteers based on their responsibilities. Well, for example, the law considers public safety volunteers, such as firefighters, to be employees for most purposes. And that's good, because this gives them the same legal protections as employees.
Any other advice?
Yes, be proactive. If you see someone heading in the wrong direction, warn them before something gets out of line. and lead by example. While much of this is common sense, if you have any questions or concerns, please talk to me or your own attorney.
Very good advice. Thanks so much for helping raise our awareness on this issue. We appreciate your time today.
My pleasure.